All right, so let's go ahead and get started then. So, thank you all for being here this morning. And we have an interesting topic here to discuss. You may or may have not heard about it. It's been floating around, the Corporate Transparency Act, and how it's going to change reporting for literally millions of entities. Um, I actually, for those of you who regularly attend our webinars, this may be deja vu for you. I actually did this presentation a year ago, almost to the day. I did it back then because that was at that point the Treasury had finalized regulations on the Corporate Transparency Act. But there was still a lot of unknowns. There was still a lot of information we really didn't have too much clarification for. And now, pretty much on the eve of this coming into effect, there's a lot more meat on the bones as with regards to reporting requirements and deadlines and so forth. So it's basically the same presentation as last month, but I've added onto it additional information that I think we're going to find useful. I noticed that, typically a lot of my webinars tend to focus on one specific group of people, for instance, real estate professionals. But this is actually a pretty diverse group that we have here, judging by the emails. I think we have real estate professionals, we have some accountants, we have lawyers, we have clients, previous clients, current clients, hopefully future clients. So what I'm going to try and do is here, I'm going to try and keep it as general as possible, because I think there's something in here for everyone, quite frankly. And there is a lot of information, and I could honestly spend hours on this, but obviously we don't have hours. So I'm going to try and keep it probably to like half an hour to 40 minutes tops, and then we can open it for questions after that. So with that said, let's get in. First of all, just just to hang on a second. There we go. Just here's my information. By the way, we'll be happy to send out a copy of this presentation, by the way, by email. We're also recording it. So yeah, anyone that hasn't had the opportunity, we're going to be sending a link for the recording. Anyway, my name is Chris Curtis. I am by trade, I'm a trust and estates attorney at the firm of Chaves Perlitz Luftig. We have a huge, you might know us with the real estate practice. We have an extremely robust real estate practice, but we also do trust and estates. I co-head that with my colleague Talita. Unfortunately, Talita couldn't be here today. She's on vacation. She's on holidays, some well-deserved vacation for her family. So it's just me taking the lead here. But we deal with trust and estates. We deal with general taxation questions regarding structuring, especially of real estate assets. And we also have a niche practice area. Me and Talita have a niche practice area, especially with foreign clients as well. We help assist foreign clients with structuring of their U.S. investments. Why is that? Because there are certain estate and gift tax issues that are unique to foreign clients that aren't unique to U.S. citizens. So it's always careful to keep those in mind, especially when they're buying real estate. So, so let's get into it. All right. So, Corporate Transparency Act has arrived. So it arrived several years ago. The Corporate Transparency Act. What is it, right? Well, first of all, it was passed by Congress. The federal law was passed by Congress in, I believe it was January 2021. It had been doing the rounds in Congress as bills, different types of bills for several years, and finally it got passed. It really is a watershed moment in transparency, especially for U.S. entities. It's going to be the first central register of entity beneficial ownership here in the United States. And the reason why this is watershed is because most countries, certainly virtually every developed country, if you were to create a corporation or some form of registered entity in that country, you have to give the ultimate beneficial ownership information. Like typically it's the shareholders, but it can be other types of information as well. And that's typically hosted in a government database that's usually searchable by the public. And it's very standard. But not in the United States. Not in the United States. The way that the United States operates by virtue of our constitutional setup, property rights are determined at the state level. So what that means is when property rights are determined at the state level, that includes formation of entities, formation of LLCs, corporations, limited partnerships, LLPs, what have you not, formation of trusts. Now, we don't have federal corporations. We don't have federal LLCs. We don't have federal trusts. Now, there are some, for instance, some, are there federally chartered companies? Yes, but those are typically very unique, usually in the banking industry, like national associations. 99.9% of the time you're dealing at the state level. So what does that mean, essentially? It means that the states regulate the information that's to be reported. Up until now, anyway, they've regulated it. And not one single state has any sort of shareholder register. No state requests the information of a shareholder, member, or a partner. They may ask for the name of a general partner. They may ask for the name of a CEO, but they don't ask for the names of shareholders. And that's very, very unique to the U.S. system. And why don't they do that? Because, quite frankly, there's competition among the states for the creation of LLCs, Delaware being the number one. And if one state was to start requesting it and being more burdensome, then not only is it going to be more expensive for that state to host that information, everyone's just going to go to all the other states. No one's going to want to create entities in that state, so they're going to lose out on that revenue as well. So there was really no incentive at the state level up until now to really create any sort of register of ultimate beneficial owners. And so the federal government decided to step in. The federal government stepped in with the Corporate Transparency Act, saying, okay, the states aren't going to do it, then we're going to do it. We're going to create some form of beneficial ownership registration. To be honest, I don't know where they came in for the lawyers out there. I think it might have been under some provision of interstate commerce or something along those lines, most likely. But they're coming in and saying, okay, well, any entity that's foreign entity that's doing business in the United States, or any entity that's registered in the United States, we want to know who's behind them. Okay. And so, and where did this come about? I mean, because, when the law was passed in January of 2021, almost 3 years ago, it was actually, we live in a very polarized political environment. Republicans and Democrats can't really agree on anything. And this Corporate Transparency Act was actually vetoed by President Trump at the time, right before he left office. And it survived the veto. They actually managed to overturn the veto with 2/3 of a vote in both chambers, which just goes to show that there is huge bipartisan support for this. And the reason being is because it's all, when you get down to it, it's all to do with tax evasion and it's all to do with money laundering, right? So what was the genesis of the Corporate Transparency Act? I think, there's many different factors, but, I just want to give a little story here just so you guys can understand why this law originates, why there's such a huge change here. I think we can go back to around 2007, and there was a huge UBS scandal. I don't know if any of you remember it, but basically the UBS, the assisted U.S. taxpayers are setting up secret offshore bank accounts in Switzerland, right? Surprise, surprise. In 2007, former U.S. banker Bradley Birkenfeld blew the whistle on the practices, right, which basically blacklisted him from the industry. The head of UBS Global Wealth Management was criminally indicted, and UBS had to pay an almost $1 billion fine and enter into a deferred prosecution agreement, right? Bradley Birkenfeld, by the way, he got a whistleblower compensation like $20 million or something like that for his troubles. So what did that end up bringing? Now, that created a huge amount of outrage because it just shined a light that previously everyone knew that there's Swiss bank accounts and offshore bank accounts, but everyone knows about Switzerland. But it didn't, it was especially galling because then we entered into a whole recession, and then there started to be the politics of are the rich paying their fair share of taxes, which goes on to this day. And so that brought a huge amount of political outrage. And so they said we need to do something about this. So the Swiss bank accounts had always been an issue, and because of Swiss bank secrecy rules. And so what did the US government do? The US government was actually very ingenious about it. They said that, okay, well, the US economy is the largest economy in the world. Let's leverage that. Everyone has a participation in it, including Swiss banks. So what they basically said was, okay, you're not going to give us the information. That's fine because of your national bank secrecy laws. But what we're going to do is, if you don't give us the information, we are going to presume that there is a US person behind that account and withhold 30% of any payments from US sources, be it dividends, be it interest. And that did the trick, right? They actually used the leverage. So then what ended up happening was they entered into what's called FATCA and IGA agreements, right? This FATCA was the act, and the IGA agreements are these international treaties, intergovernmental agreements between different governments. And that was enormous. Basically, what the Swiss government agreed to, as well as other governments all around the world, was to, if there are US persons or indicia of US persons, like a US address for bank accounts abroad, we're legally obligated to provide this to the US government, right? And in the return, the US government would get information about those tax residents, but it was a huge victory for the US government, essentially. And then the world strikes back. Okay, well, if the U.S. government's going to strong arm us with all these IGA agreements and everything, and with FATCA enforcing us to get information on U.S. persons, then we're going to enter into our own common reporting standards, and that's where CRS comes in. So the world strikes back. Basically all the rest of the industrialized earth said, okay, we're going to have something even more robust. We're going to have something that gives us a clear line, shines the light of any sort of bank accounts that are held by entities and structures and so forth, going right to the heart of the individual. So they established it, and that's what is in existence right now in the world today. And these are automatic exchange of information, right? So the banks are obligated to get information on the account holders right down to the individual, send that information to the local tax authority then sends it to the foreign government. And they exchange these informations. The U.S. did not enter into the CRS. The U.S. stayed out of it. And the U.S. just, now we're quite happy with our FATCA rules here. Why is the U.S. happy with those FATCA rules? Because FATCA rules are a lot less transparent than the CRS rules. So what essentially ended up happening was probably around 2016 when this came online, is the U.S. essentially turned into the new Switzerland, right? Everyone started calling it the new Switzerland because now it was easier to hide funds in the United States than it was in, say, Switzerland, where things were a lot more transparent, ironically enough. So, then, there was this heavy criticism by the international community. The international community was like, well, the U.S. is criticizing Switzerland, criticizing the British Virgin Islands, Panama, yet they have robust UBO, ultimate beneficial owner reporting. So the international community started criticizing the United States, saying, "Hey, you don't even have shareholder registers on the state level, and here you are pointing the finger at us, saying, accusing us of tax evasion. What about you guys?" So that looked really bad for the United States. So eventually, it got to an embarrassing political level that the United States figured, the U.S. government figured, we have to do something because nothing's going to be done on the state level. So that is, bottom line is, the whole world is starting to move towards more transparency, right? It's, compared to the 80s and the 90s, I mean, it's such a different world. Back then, it was a free-for-all. You had, bearer shares, and no one knew who was behind any sort of entity. Banks didn't know, but those days are long gone now. Long, long gone. So, and just to give a very quick example, right? How was it that typically, if someone wanted to launder money, for instance, they would typically buy U.S. real estate. U.S. real estate is very valuable. It's very stable, at least most of the time. So what would they do? They would form like a Delaware LLC. There was no requirement to report the name of the owner of the LLC to the state of Delaware. Delaware LLC is then used to purchase valuable real estate in New York City. No name appears on the deed, only the name of the Delaware LLC. So long as the LLC had no rental income and the apartment wasn't sold, historically, no requirement to file any information or returns with the IRS. And even then, shady characters could use, for instance, just, straw men. There was really no way of, technically, was it legal, illegal? it was technically illegal, but there was no real enforcement of it, right? Such practices, by the way, have been curbed by New York City for several years now, but for the rest of the United States, it was an issue. So then the Corporate Transparency Act. So I just mentioned this, so I'm going to go through this, but yeah, it was passed. It was passed with bipartisan support, and FinCEN actually issued final rules implementing the reporting requirements back in September of last year. That's why I did a webinar on this last year. But they really haven't given much information until fairly recently. So, and now obviously we're on the eve of it. I figured it would be a good time to do it. So let's get into kind of the heart of the reporting, right? What is considered a reporting entity, right? Reporting entity is what actually has to report. So for domestic entities, right, we have to distinguish between domestic entities and foreign entities. Domestic entities is basically, and I'm going to tell you this right now, a common thread here with the Corporate Transparency Act is how the definitions are so broad. They are very, very broad. It is very hard to avoid this reporting, all right? And that's intentional, that's deliberate, because they don't want anyone trying to find any sort of loopholes in it. So it is intentionally broad. Now, for domestic entities, it is basically any entity formed via some form of filing or registration, which will be required to report annually. So that includes like LLCs, it includes corporations, it includes limited partnerships, limited liability partnerships, basically any entity that's formed that requires a filing with a state secretary of state, right? So if you need to register some way, it needs to have a filing process. So that really encompasses pretty much anything, right? Now, let's compare and contrast that to a foreign entity, right? So it's basically a foreign entity, obviously, is only as a reporting entity only if the foreign entity is registered to do business in the US, and any foreign entity de facto engaging in a US trade or business in the United States. So quick example here. Let's say, for instance, you have British Virgin Islands Corporation that directly owns real estate in New York City. It's titled in the British Virgin Islands Company, and it actually rents it out and it's receiving rental income. Now, technically, the British Virgin Islands Company is meant to have registered to do trade or business in the United States, the New York State Department of State. Some of them do, some of them don't. And but it's actually doing trade or business de facto. So regardless of whether or not that foreign entity actually registered to do trade or business, because it's doing business in the United States, it's required to report the ultimate beneficial owners. So it's sort of like a question of fact. Is it actually doing trade or business, right? So again, it's meant to be very broad. It's meant to catch any foreign company doing a trade or business in the United States. And that's a question of fact. So what is not considered a reporting entity? Like I said, it's very broad. So there's really not many out there that can go under the radar here. Basically, foreign entities not engaging in a trade or business in the United States. For instance, it just holds a bank account with passive income, like a brokerage account, right? So you've got that same British Virgin Islands company, but it just holds a brokerage account with stocks, bonds, and things like that, just passive income. That's not trade or business in the United States, so it's not required to report. Unregistered organizations is another one. These are very rare. These are very, very rare. You're talking about sole proprietorships. It's just basically like you doing business in your own individual name. And general partnerships. General partnerships, by the way, is just basically the sort of default rule when two people get into a partnership to make a profit, to go into business to make a profit. There are default partnership rules, and there's no registration required for that. But those are very rare. I think I've seen one of them in my career from like the 60s or the 70s, where there was a general partnership agreement. If you are an attorney, by the way, and you have your clients enter into a general partnership, you are likely going to be sued for malpractice because there's no liability protection with those. So they're almost non-existent these days. The third is trusts. Trusts, there's no requirement to register a trust prior to being established, right? Those are private documents. They are similar to contracts, right? Maybe there are going to be certain things like business trusts, very specific business trusts, but just your general average revocable, irrevocable trust, those aren't required to be registered here in the United States, so they fall out of that reporting requirement. Number four is certain regulated entities, banks, governmental entities, insurance companies, publicly traded securities, public utilities, that sort of thing. And then number five is large operating companies. So it has offices in the US, minimum of 20 employees, and 5 million in gross receipts per year. I mean, the logic behind that is they are reporting in some other way, right? And you don't want Coca-Cola to have to Coca-Cola or Apple to have to give the ultimate beneficial ownership information of literally millions and millions of shareholders, right? That would be completely ridiculous. So let's talk about what's going to be reported, right? Following information is going to be reported to FinCEN. FinCEN's the ones collecting this information. And this is what we're going to need. Obviously, it's company name. If it has a DBA, which is a doing business at, or a trade name, it needs to report that. It needs to report its address. It needs to report state of information, an EIN number. EIN number, by the way, is like an entity tax ID number for those that may be unfamiliar here in the US. And by the way, any entity, even it's got a foreign owner, can apply for an EIN and should apply for an EIN. And by the way, EINs can sometimes be a bit of a pain to obtain, so it's best to apply for these as early as possible. And then, so that's for the company. Now, for each beneficial owner of reporting entity, we need the full legal name, we need a date of birth, we need a current address, and we need some form of unique identifying number for that person. It could be anything. It could be a foreign tax ID number, it could be a passport number, it could be a driver's license number, and so forth, right? But that's the information, that's basic information that we're going to need. So, and who is considered a reportable beneficial owner? Well, first of all, and it's something that I do want to stress as well, is that there are going to probably be some people that are going to think, well, why do I just put the shareholder as an offshore corporation or multiple layers of different entities? That's really not going to work. That's not going to work because you have to eventually get to an individual that has control over it, right? So the reportable beneficial owner. Beneficial owner is defined as any individual who directly or indirectly owns or controls 25% or more of the reporting entity, or exercises substantial control over the reporting entity, such as a CEO. And so that's an important distinction to make here, because, for instance, Congress is looking at this when they were creating the rules, and they thought, well, hang on, and I've seen this before. Someone creates a corporation, but they don't actually issue shares, right? They don't issue shares. They actually issue loans to the corporation, right? So they everything's a loan to the corporation instead of shares. And so Congress was all obviously thinking about these things, and they were thinking, well, if someone gives a loan, then they're technically not a shareholder, so we have to be careful. But they'll still be, like, say, for instance, the director, or have control over the director. So that's why they put this additional requirement here to exercise substantial control, right? So if you have a CEO that has substantial control under the bylaws, under the operating agreement, and so forth, then the officers with such substantial control are also going to have to be reported as well. Again, catch-all. They want to be as broad as possible to make sure that they know who is controlling these entities and behind these entities. And then also very important, this is very important for the lawyers out there, for the corporate formation service people out there who form companies and entities on behalf of your clients. For any entity created after January 1st, 2024, a company applicant must be reported, defined as the person who files or registers the entity. This can encompass legal and accounting professionals forming an entity on behalf of clients. Very, very important, right? And by the way, that information is not going to go away. Now, of course, it's important to note there is a distinction between company applicant and beneficial owner, okay? You're not going to be considered, company applicant isn't necessarily going to be considered the beneficial owner, so don't worry about that, right? Because this is a concern of mine as well. I form entities all the time routinely for my clients, right? But it is important for you to understand that this is going to be a new requirement. You don't want to get penalties for this. So what are not considered beneficial owners? So, for instance, a minor child is not considered a beneficial owner. And that's defined under the laws of the state where the entity is formed, but only so long as the information of a parent or guardian is reported, right? So again, they're trying to close all the loopholes here. They don't want, some corrupt politician in a foreign country establishing an LLC in the name of his 2-year-old child, right? An individual acting as a nominee, right? Intermediary or custodian, because you can get that. You can get nominee agreements. Nominee agreements are actually perfectly legal, right? But they don't want that, they don't want, for instance, Chris Curtis as the nominee of his client to be reporting his name instead of the client's name. No, Chris Curtis ultimately has to report the name of the client, even if there is a nominee agreement where Chris Curtis's name is on the share certificate as nominee. Number 3, a non-owner employee of the company, right? Except for what I mentioned, high-level executives and officers. 4, an individual whose only interest is in the entity is a right of inheritance. What do I mean by that? It means, like, let's say, for instance, a trust owns, a revocable trust owns the shares, very common, shares of a corporation. And you have the settlor, the creator of the trust, and you have his or her children who are the beneficiaries in the event of their death. The children are not considered they're not considered ultimate beneficial owners because they don't really have control of it. They only have a mere expectancy, an unvested interest in the future that could change at any time. So they don't have to be reported. They're not considered reporters. And last but not least, the creditor of the entity, right? A creditor. And again, a creditor of the entity, like a mortgage company, right? Mortgage company that has a secured interest on any of the assets of the company, so long as obviously it's bona fide. So what is considered an ownership interest, right? And again, very, very, very broad. Equity, stock, or voting rights, naturally. Capital or profit interest. Convertible instruments such as a convertible loan, an option or privilege to purchase in the future. And then last but not least, they have a catch-all provision, which is any other instrument, contract, arrangement, understanding, relationship, or mechanism to establish ownership, right? So they're being very, very broad here. If someone has any kind of inkling of a potential interest or ownership right or controlling of the company, they want to know about it, okay? And I just added this here, actually, sorry, I didn't give a credit, but I put this, I stole this from FinCEN. This is the company applicant reporting. I think it's just, I think it's important to put this here, which may apply to lawyers or corporate formation companies I had mentioned. So this is just basically the timing for this. So if the company was created on or after January 1st, 2024, right, then we have to require to report company applicants. Before, you're not required to report company applicants. So for those of you like me that create a lot of entities and have created a lot of entities in the past, you can breathe a sigh of relief. You're not going to be required to go back into your matters and make a huge list and try to figure out everything that you need to reporting. It's only for entities that you create for a client after January 1st, 2024. All right. But do keep that in mind. Keep notes, right? Keep notes of the entities that you're creating after January 1st, 2024, because you are going to have to report if you were the one that actually filed, for instance, articles of organization or articles of incorporation and so forth. Now, here is the most important part, and probably what everyone here is thinking about, right? Because the title of mine is "Are You Ready?" of my webinar is "Are You Ready?" So it comes into effect on January 1st, 2024. Now, the good news is that you can breathe another sigh of relief, because for any entity formed prior to January 1st, 2024, such entity shall be required to report no later than January 1st, 2025. So those entities that already exist before January 1st, 2024 has a whole year to enter into compliance, all right? So breathe the sigh of relief. You are not going to be required to report on January 1st, 2024, okay? Little bit of marketing, maybe shenanigans on my part for my webinar, but important that everyone knows this information regardless. Now, the same is not true for entities that are formed after January 1st, 2024. And this is really kind of the crew of why I'm doing this webinar, right? Because now then after the new year, just because it's good for everyone to be kept apprised. An entity formed after January 1st, 2024, reporting must be completed within 90 days of the entity's formation. All right. And then all entities will be required to report beginning January 1st, 2025. All right. So for all entities, now another important point, for all entities created or registered on or after January 1st, 2025, they will have 30 calendar days from the entity's formation to file their initial report for FinCEN, right? So you can see here the 90 days for the first year of any newly formed then goes down to 30 days, right? So keep that in mind, right? That 90 days is sort of FinCEN, the government's trying to be liberal here. They understand that not everyone's going to get aware of this. They're trying to do an outreach campaign and so forth. So basically, you're going to have 90 days for any newly formed formation for a year. But then after that, the little holiday's over, and then January 1st, 2025, anything that's newly formed, 30 days required reporting. Now, it's important to mention, let's say, for instance, because I have had these questions before, is this going to be a requirement every year, right? Every year to report this information? Short answer is no. This isn't going to, this is in theory a one-time reporting requirement. So you report the beneficial ownership information, and then after that, you are not required to report that on an annual basis or file anything on an annual basis or so forth, as long as there isn't a change of the information, obviously, right? And so only a change in the information and the underlying ultimate beneficial ownership information would require some form of update and filing, right? So, and what kind of change in information would trigger an update? Well, pretty standard. Change in business name, change in beneficial owners, obviously. The sale or a gift or a transfer, that has to be reported as who the new person is. A change in beneficial owner's unique identifying number, so they need to update their passport number, for instance, or tax ID, or driver's license number. Change of address, change name. By the way, inaccuracies must be reported within 30 days of the date that the entity becomes aware of the inaccuracy, right? So again, FinCEN, at least at the very beginning, they're going to be very lenient about that. If you find a reporting inaccuracy, then must be corrected within, at least initially for the first year, it's 90 days. They're giving 90 days. From when you discover the inaccuracy, you have to report it. But then after that, the party's over and the honeymoon's over, and then it's going to be 30 days, just like it is with regular reporting. So before I go on, I just want to bring this up because some of you might have this question, so I'm already going to answer this ahead of time. Like, where do you register, and where do you register, and what does the database look like? So you're going to register on a FinCEN portal. It's all online. It's entirely online. However, the portal hasn't come online yet. The portal's not coming online until January 1st, 2024. So unless you're in FinCEN or in the government and working on it, none of us actually know what that portal actually looks like. So we're only going to find out on January 1st, 2024. So we can't even see it, but it will all be online, by the way. Now let's discuss there are some exempted entities, but again, I have to stress, exempted entities is extremely narrow definitions here. Again, they want to have a catch-all. They want as much information as possible. But there are two exempted entities. And what are they? The exempted entities, for instance, are tax-exempt entity exemptions, 501c3 charitable organizations, for instance. The second one is the inactive entity exemption, right? When a company was created maybe years ago and it was just you created it and then never got rid of it, but it's just inactive and it's not doing any business. Obviously, we don't want people to have to figure out like, oh, did I create a company in 1980 that I never used? Obviously you're not going to have to report that company. That would be insane. But what are the criteria? Tax exempt entity exemption. I'm not going to read through this. I'll send you guys out, but this is all the code stuff. But basically, it's any charitable entity, political organizations, and so forth, because those are already regulated on a certain level, more rigorously regulated than other entities on the federal level. So basically, those are typically exempt. But let's get into the inactive entity exemption, right? So an entity qualifies for the inactive entity exemption if all of the following 6 criteria apply. So just see how restrictive this is. You have to, the entity to qualify the inactive entity, it has to qualify for all this criteria. It was in existence on or before January 1st, 2020. The entity is not engaged in an active business. The entity is not owned by a foreign person. The entity has not experienced any change in ownership in the preceding 12-month period. The entity has not sent or received funds in any amount greater than $1,000. Either directly or indirectly, and the entity does not otherwise hold any kind of type of asset, whether in the United States, abroad, including ownership interest in a corporation, limited liability company, or other similar entity. Right. So basically, the bottom line is, it really has to be an inactive entity exemption. They're closing all the loopholes here. So yes, if you created a company back in 1985 and you decided, but you never liquidated it, and you decided you never wanted, you never used it, or you used it for a few years and then haven't used it anymore, you're not going to have to report that, right? But but look, have to keep in mind all of these different requirements. Now, let's just talk about practical aspects, right? Because let's say, for instance, because one of these is a foreign person, right? If you're a foreign person, so one of the requirements for foreign person, let's say you're a foreign person that created a corporation in 1989, and you just never used it. You created a New York corporation, you never used it. Technically, it's still in good standing because you never dissolved it, right? Technically speaking, you don't qualify for the inactive entity exemption, right? In theory, in practice, and look, I can't say, I'm an attorney, I can't say to break the law, you should be reporting, but at the same time, the practical aspects of it is just that, unless they really wanted to go after you, you're not going to, especially if it's in good faith, so long ago and you forgot about it and you can't find the information about it, then, I wouldn't worry too much about penalties, certainly not criminal prosecution or anything like that. Now, here's a good question. And one of our participants here actually asked me this question before the webinar, and I thought it was a good question. Actually, there's so much information that I'm going through, and I thought it was a good question in order to bring up. So thank you for that question. But question is, what happens if an entity ceases to exist or is dissolved? Okay. So let's say, for instance, you say, okay, you dissolve the entity today. What happens then? So number one, if an entity does not exist on January 1st, 2024, so you file like articles of dissolution, what have you, with the state, and then it's dissolved before January 1st, 2024, it will not need to file a beneficial ownership report. All right. Number two, if an entity begins the dissolution process in 2023 and completes it by the end of 2024, sometimes it takes a while to dissolve an entity, then on the January 1st, 2025 deadline for entities formed prior to January 1st, 2024, mind you, the entity will not exist and will not need to file. Right. So that does not apply, by the way. Just the general rule is, if the entity is formed after January 1st, 2024, it needs to file. It's not going to avoid it. This whole dissolve, cease to exist only applies to entities formed before January 1st, 2024. Okay. But yes, if it's dissolved, then generally speaking, if it's dissolved before 2025, then it should be good and shouldn't be required to be reported, so long as it's already existing right now. Now, who can access the reported information, right? It's going to be public, it's going to be private. It's not going to be public, all right? So breathe a sigh of relief if you're concerned about privacy. It's not going to be public. It's going to be treated more like tax information, similar to income tax returns that you have with the IRS. It's not going to be available to the general public. It's going to be stored in a secure database, similar to level of protection as tax information. There are some organizations that are obviously going to be permitted to use it, right? Because it's usually for money laundering, for investigation, tax evasion, so forth. So naturally, federal, state, local, and tribal officials are going to be able to access it. Foreign officials who submit a request through a U.S. federal government agency, because the U.S. government has treaties with multiple foreign jurisdictions that allow the foreign governments to subpoena certain information when they are, for instance, like tax evasion and so forth. But they did limit it, just to be clear, for for foreign officials that are making the request for the information. It can only be for activities related to national security, intelligence, and law enforcement. Okay. So, for instance, why do they put this? Because they don't want foreign officials. They don't want foreign officials to be politically motivated, right? If someone's using it, otherwise it's really perfectly legal, but they're trying to embarrass or humiliate a potential political rival, let's say, then they have a certain level of discretion to deny that request. And then finally, financial institutions, financial like banks, but only with the consent of the reporting company. Obviously, that's important. But if you open up a bank account, for instance, in the name of a company, whether it's offshore or domestic, they're always going to want the shareholder information anyway. So it's kind of de facto you're going to give that to a financial institution. So what are the penalties? Okay, so let's say you did not heed my instructions, you did not attend this webinar, and a year goes by and you have not filed anything, and then it catches up. What happens then? Well, there's two types of penalties. There's civil and there's criminal penalties. Civil penalties up to $500 per day for each day the violation continues or is not being remedied. That's a lot of money. There's also a criminal penalty up to a $10,000 fine or prison sentence up to 2 years of both. Now, in my experience, let's talk about penalties and the possibility for penalties. In my experience, they're going to be very lax about penalty enforcement. They really are. We're probably not going to see any penalties for a couple of years, realistically, but they soon will do. The criminal penalties are very, those are going to be very rare, right? Because you need to show what we call CN, so you need to show intent to evade, and that's very, very difficult to bring a case like this. So realistically, you may see civil penalties. They might be able to be abated. The criminal penalties is going to be very, very rare. Those are going to be reserved for the most egregious cases. And what are the effects on estate plan? Because after all, I'm a trust and estates attorney. Well, trusts by themselves are not subject to reporting, right? But bear in mind, if the trust owns, for instance, shares in a corporation, they are going to be subject to reporting. Or into an LLC, they're going to be there. You're going to have to tell who controls that trust, which is essentially the settlor of the trust. For instance, it's a revocable trust. Trust information may need to be reported if the trust beneficial ownership of the reportable entity, closely held business, family business, right? That's going to have to be reported. Doesn't matter if you're filing an income tax return every year, you're still going to have to make this separate report. And that includes also potentially when you have structuring with family limited partnerships and private trust companies. All right, we come to the end. Sorry, I think it took a little longer than I thought it would, but obligatory disclaimer. This information presented is not intended to be legal advice. I'm not your attorney. If you want me to be your attorney, feel free to reach out to me, but I'm not your attorney. As is, no representations that the content is error-free, blah, 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 blah. All right. And, if anyone has any questions, let me just see here. I have a chat. Let me just take a look real fast. So let's see here. Will reporting be done online, John Zimmerman? Yes, reporting will be done online. It will all be done online on the FinCEN website. So if you do Corporate Transparency Act FinCEN, you're going to if you Google that, you're going to eventually, it's going to be number one. Gretch, 1. So if a trust owns the shares of the LLC or corporation above 20%, you're required to disclose the immediate beneficial owner of the trust. Yes, of course, it depends on the trust. But let's say, for instance, a revocable trust, the settlor of the trust, who has the power to revoke the trust, that's who you mentioned. Even if the beneficiaries, sometimes beneficiaries can be different from the settlor. So the settlor is the one, because the beneficiaries essentially, if the trust can be revoked or amended, then they don't really have any real legal rights to anything, right? So it's the settlor. And then number 2, what if you buy an existing LLC real estate in 2024 that was created prior to 2024? if it was created prior to 2024, then so if it was created prior to 2024 and you purchase it, then if there is the first initial registration for the LLC, it was created prior to 2024, it doesn't have to register until January 1st, 2025. But then any change of owner, that's a good question. But then any change of ownership in that would have to be reported within 90 days. There's a bit of an ambiguity there in the rules, right? I don't know the answer for that, at least for the first year. If it's after the first year, then it's very clear. The rules are very clear. What I would do is, if there is a change in ownership, at least in the first year, I would just err on the side of caution and then just report the initial owner and then also the change of ownership within 90 days. That ownership, there's a change in that ownership. That's what I would do. I would err on the side of caution for the first year, from up until January 1st, 2025. After January 1st, 2025, it has to be reported within 30 days. All right. John Zinmany. If my medical professional client transfers ownership real property from personal to LLC, will we need to report the change? Yes, but it's not triggered by the transfer of the real property to the LLC. It's triggered by the actual formation of the LLC. So once the articles of organization are filed with the secretary and accepted by the Secretary of State and it's officially registered, that's what triggers the deadline for the reporting requirement, independent of whether the LLC owns any assets or not. And Andrea, I heard that a New York State version of this law says the information submitted will be made public. Is this true? I haven't heard anything about this, Andrea. I'm not aware of any New York State law that's going to make anything public. I might be wrong. I haven't heard about it, though. I think what you may be referring to, I think there were some proposals out there several years ago, especially with the Panama Papers and all the outrage with that. And then some lawmakers here in New York State were starting to consider bills. They were trying to pass bills to actually make a public register of beneficial ownership information here in New York State that could be searchable. And I don't think that ever gained any traction. I think that's what you might be thinking of. I'm not familiar, but if anyone knows anything, then please do correct me. And will there be a copy of this recording presentation? Yes, this is being recorded, and we'll send out a copy of this presentation and also a link of the recording as well. So, all right. So I think that's it for questions. I'll just give it a couple more seconds if anyone has any additional questions. But if not, I guess that is the end of this webinar. And oh, hang on, one more. If I formed LLCs prior to 2024 for a client and no longer represent the client, what are my obligations to file? You have no obligations because your obligations for the formation to a client is only as a company applicant. So if it was formed before January 1st, 2024, you have no obligations to register as a company applicant. It's only for any entities registered after January 1st, 2024 that you have obligations as a company applicant. So don't worry about that. All right. Is that the last one? Oh. Thank you you're very welcome. Based on your slide, I qualify for the inactive entity exception as the single owner of an inactive LLC registered in 2015. Would I be better off filing with Kevin? And this is a question by Kevin. Would I be better off filing with FinCEN anyway? It doesn't hurt. It doesn't hurt. If you want to be on the conservative side, yeah, you may want to consider it or dissolve the entity. Either way, it certainly doesn't hurt. I won't say no to that. Any more? Going once. Going, you're welcome, Andrea. Going twice. And I think we are all done. So thank you, everyone. If you have any additional questions, feel free to reach out to me. My email. If you have any clients, if you have any questions, trust in the States, foreign clients, looking for, especially foreign clients. I deal with domestic clients, but also foreign clients, structuring, real estate, and so forth. Have any questions, feel free to reach out to me. Always happy to help. All right. And thank you, everyone. And this concludes the webinar. Take care and happy holidays to you all.